The Supreme Court has just dealt a huge blow to organized labor.
In a 5-4 decision, the court ruled government workers cannot be charged for the cost of collective bargaining if they choose not to join a union. The ruling overturns laws in 23 states. We're going to dig into exactly what that means. Joining us now, Jeffrey Rosen, President and CEO of the National Constitution Center.
Jeff, good to see you. This ruling overturned an earlier decision. Can you just walk us through what has happened?
Absolutely. That earlier decision, called the Abood case, was from 1977, and it said it was okay to force public sector unions to pay mandatory fees, not to support political activities, but to support collective bargaining. And in this 5-4 decision today, which, as you said, is hugely significant, the court overturned that decision, said that for a person to be forced to pay to a union whose political messages he may disagree with, it violates his First Amendment rights not to have compelled speech, and therefore mandatory union fees are unconstitutional. The decision could have tremendous consequences. As you said, 23 states have these laws. They involve millions of employees and tens of millions of dollars that now will not go to the unions. It will change the way states finance their activities. And Justice Kagan, in her dissent, said there was no justification for overturning the Abood decision, and this would dramatically disrupt our understanding of the relationship between unions and the government.
So the interesting part about this, and you'll see this, President Trump has already tweeted about this morning, saying it's about free political choice. So if you don't like laws that cause people to have to subscribe to unions, then you say that it's about political speech, right? These unions are political entities. They are the power behind a lot of candidates. On the other side, before we had unions and collective bargaining, we had things like the Triangle Shirtwaist Fire, where there were no rules for employees. The Constitution is kind of silent on both of those things, right? Whether unions can have political power or whether people have a right to collective bargaining.
It absolutely is. Of course, there were no unions at the time of the founding, but during the Progressive era, when unions really got up and running, there were plenty of laws passed by Congress in the states that required things like mandatory fees, and the Supreme Court never questioned any of them until today. This question of compelled speech is a huge issue this term. Just yesterday, the court said that pro-choice clinics in California couldn't be forced to have pro-choice information, and the liberal justices are saying the conservatives are using the First Amendment as a cudgel, basically to strike down regulations that they disagree with.
And I'm just looking at, I want to put up a map here, Jeff, of states that have so-called right-to-work laws, right? Rights to do whatever you want without any compulsions to join or pay for a union. There are a lot of them in the United States. Does this does this pave the road for a federal right-to-work law?
Sure, if there's the will in Congress. And as Justice Kagan said, it's been a 6-year campaign by conservatives to overturn the Abood decision. Of course, states were always free to pass right-to-work laws if they chose. But the bottom line is that public sector unions are now really in peril. Their funding source is in trouble. They wouldn't be able to lobby against a right-to-work law. And therefore, the writing is on the wall that there may be further blows to their power.
Hey, MSNBC fans, thanks for checking out our YouTube channel. Subscribe by clicking on that button down there and click on any of the videos here to watch the latest interviews and highlights. You can get more MSNBC for free every day with our newsletters. Just visit msnbc.com/newsletters to sign up now.